Senator Josh Hawley just asked a law professor a simple question. What is the principle that makes nationwide injunctions wrong under Biden but acceptable under Trump? The professor could not answer. She said Trump is engaged in more lawless activity.
You don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think
you must
this
concede that
was
as a
never
possibility.
used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction?
Hawley asked again. She said single-judge injunctions are a problem. Hawley asked again. She said her view of the underlying legal question colors her perception. Hawley said that is not a principle. He said the translation is simple. You just don't like the outcome. He said a legal system that switches principles based on political preference is not practicing law. It is practicing politics. Let's watch.
Thank you very much, Mr. Chairman. Mr. Chairman, it's great to have this hearing. Thanks for calling it. Thanks to all of our witnesses for being here. Professor Shaw, nice to see you again. Let me just start with you, if I could, Professor Shaw. You talked about the fact that there have been lots of rulings against the Trump administration. That's absolutely statistically true. I disagree with almost all of them. In fact, I think all of them. But the issue of this hearing really isn't the rulings, is it? It's the remedies. Would you agree? And those are distinct things. You may think that the ruling is quite correct, but that's actually not what we're talking about here today. We could have a hearing on that. Maybe we should. But we're talking today about the remedy. And the question is a remedy that binds parties who are not before the court, is that an appropriate thing? I mean, aren't you concerned about judges binding non-parties in their remedies? You may love the ruling, but even if you do, don't you think it's a little bit anomalous for courts to be going out there and binding parties who are not before them? I mean, is that something we want to encourage?
Senator, I think that judges have been issuing rulings that impact non-parties since Marbury versus Madison, right?
So you're not concerned about it?
I'm not. I absolutely think that they can be abused, and they have been abused.
Wait a minute. You were very concerned about it just a couple of years ago.
Yeah.
You said in response to a nationwide injunction on the Biden FDA's mifepristone rules, and I quote, "This injunction's a travesty for principles of democracy, notions of judicial impartiality, and the rule of law."
I think I've been consistent today. That was issued by Judge Kaczmarek in a single judge division. They're a problem. Those are a problem.
With him personally? Wait.
No.
So your testimony is if it's issued by Judge Kaczmarek, it's bad?
No, sir.
It's personal?
That is not my testimony.
Is the problem with the injunction? You were criticizing the universal injunction
issued by a judge in a single judge division. I've been very clear today that those are a problem.
By a Republican judge in a Republican division, then it's bad.
No, Senator.
Otherwise, it's fine.
No, Senator. I think that single judge divisions
What is the
are a problem.
principal difference? I'm looking for a principle. I understand you hate the president. I understand you love all of these rulings against him. You and I both know that's not a principle. You're a lawyer. What's the principle that divides when issuing a nationwide injunction is okay when it's not? When the Biden administration was subject to nationwide injunctions, you said that they were travesties for the principle of democracy. You didn't say the referral to Judge Kaczmarek was a travesty. You said his injunction was a travesty for principles of democracy. Yeah. So, in other words, the translation is just you didn't like the outcome. Is that right?
No, Senator. Look, we're talking about, I don't think Article 3 precludes this form of relief. So we are talking about prudential consideration.
Prudential meaning political?
No.
Then give me, so far I have yet to hear it. You've been questioned by multiple senators. I have yet to hear a principle other than the fact when you like the ruling, you think it's great to apply it nationally, including non-parties. When you don't like the ruling, it is a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law.
Look, Senator, I'll say I think I am self-aware enough to know that my view of the underlying legal question, I am sure colors my perception of the remedy. I think that we should all acknowledge that. And yet I do think
that why shouldn't we stop nationwide injunctions for everybody?
I think
That's what we're talking about today.
Because I'm not willing to leave without relief non-parties who are
injured.
No,
you're not willing to leave without the ability to bind President Trump.
No, I
right?
think that...
I mean, when it's Biden, it's okay. No. When it's Biden, it's a travesty. When it's Trump in office, it's no holds barred, whatever it takes, right?
I believe in a powerful...
What was it that President Biden's staff said? We've got to do undemocratic, unconstitutional things to save democracy. Why is this the same
I believe in a powerful president. I do believe in presidential power, but power and constraint are not at fundamental odds.
What is the principle? What is the principle? The legal principle. You've referenced prudence. You've referenced the judges you don't like. What's the principle of when an injunction binding non-parties, which was never done in this country before the 1960s? And let's see the chart, the Trump chart, which was done really only once Trump came into office for the first time. You don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think
you must
this
concede that
was
as a
never
possibility.
used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction, and then when Biden comes to office, no, actually.
It's Republican appointees as well, Senator. And the 1960s is where some scholars sort of locate the beginning
Can you
of this,
identify
but
one
others.
before then?
Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first. There were others in the 20s.
The Republic endured for 150 years before there was a nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system of law.
That's not what you thought when Joe Biden. That is not what you thought when Joe Biden was
every president
You
is
said that is
constrained
not what
and
you
must
said.
be.
You said it was a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said
the Supreme Court senator agreed 9-0 with me on that.
You also said when Joe Biden was president, you said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just judges looking like politicians in robes. Again, it threatened the underlying legal system. People just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed. And the combination of parties without standing and the single-judge division.
No. We're talking. No, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
issued in a case where no one had standing.
Here's the thing. We've now gone 6 minutes, and Senator Kennedy had you for 6 or 7. You couldn't identify a single principled basis. We all know the truth here, which is it's not just you. It's most of my colleagues over here on this side of the aisle, who I respect a great deal, and they were raising very principled objections to the nationwide injunction just 6 months ago, maybe 9 now. And you're probably right. My point is that all that's changed in 9 months is the occupant of 1600 Pennsylvania Avenue. And I realize that my colleagues on this side of the aisle very much dislike that individual, and I realize that you think that the rulings that he has lost are fundamentally sound. We might grant all of that. I disagree with all of that, but we can put that to one side. The question we're talking about here is, should judges, single judges, district court judges, be able to bind non-parties who are not in front of them? And you used to say no, now you say yes. Let's be consistent. I would just suggest to you our system of government cannot survive if it's going to be politics all the way down. Thank you, Mr. Chairman.
Can I briefly respond?
Sure.
I mean, you invoked democracy a couple of times there, Senator. Judges are part of our system of democracy. Democracy is not as simple as majority rule. Judges have always served something of a
You would have it be as simple as
function.
majority rule. When you get the majority you like, you're for the nationwide injunction. When you don't, you're not.
Senator Josh Hawley just delivered a masterclass in how to expose a double standard at the heart of the legal establishment. He did not come with a speech. He came with quotes. He came with past statements. He came with the professor's own words, and he left no doubt about the answer. The exchange between Hawley and the law professor was not just a routine oversight hearing. It was a confrontation about the fundamental question of whether the rule of law is applied equally to everyone or whether it is a tool of political power. Hawley began by laying out the professor's own past statements. When the Biden administration was subject to nationwide injunctions, the professor called them a travesty for principles of democracy, notions of judicial impartiality, and the rule of law. She called the idea that anyone would forum shop to get a judge who would issue a nationwide injunction just politicians, just judges looking like politicians in robes. She said it threatened the underlying legal system. She said people were just trying to get the result they wanted. She said it was a travesty for the rule of law. These were not casual remarks. They were strong, principled statements about the danger of nationwide injunctions. They were statements about the integrity of the legal system. They were statements about the importance of judicial restraint. Then Hawley asked the question, what is the principle that divides when a nationwide injunction is okay and when it is not? The professor could not answer. She said she does not think Article 3 of the Constitution precludes this form of relief. She said they are talking about prudential considerations. Hawley asked if prudential meant political. She said no, but she could not explain what it meant. The word prudential is a lawyer's way of saying, we don't have a clear legal rule, so we will make a judgment call. That is not a principle. That is discretion. And discretion that always seems to favor one political outcome over another is not discretion. It is bias. Hawley pressed. He said he had yet to hear a principle other than the fact that when you like the ruling, you think it is great to apply it nationally. When you don't like the ruling, it is a travesty. The professor admitted that her view of the underlying legal question colors her perception of the remedy. Hawley said that is not a principle. He said that is just preferring the outcome. The professor's admission was honest. She acknowledged that her view of the remedy is not neutral. It is shaped by her view of the underlying legal question. But that is precisely the problem. A judge or a scholar should apply the same rules regardless of whether they agree with the underlying policy. If the rule is that nationwide injunctions are a travesty, they are a travesty regardless of who is president. If the rule is that they are acceptable regardless of who is president. The professor could not articulate a rule that applies equally to both. The professor then offered a different explanation. She said Trump is engaged in much more lawless activity than other presidents. Hawley did not let that stand. He said that must be it. He pointed out that nationwide injunctions were never used before the 1960s. Suddenly, Democrat judges decided they loved them. Then, when Biden came into office, they were a problem again. The professor tried to argue that the federal government was doing a lot less 100 years ago. Hawley said that does not explain the double standard. He asked how the system of law can survive on principles that switch based on who is in the White House. The professor's argument about Trump's lawlessness is revealing. She is not arguing that nationwide injunctions are inherently wrong. She is arguing that they are necessary because Trump is uniquely dangerous. That is not a legal argument. That is a political argument. It is an argument that the ends justify the means. It is an argument that the normal rules do not apply because the threat is so great. That is the kind of argument that authoritarian regimes make. They say they must break the rules to save the country. They say they must suspend the Constitution to protect democracy. The professor did not realize that she was making the same argument. Hawley did. The professor then said a system with legal constraints on the president is a very dangerous system of law. Hawley said that is not what she thought when Biden was president. He read her own quotes back to her. She said nationwide injunctions were a travesty for democracy. She said they threatened the rule of law. She said they made judges look like politicians in robes. But now, with Trump in office, she is fine with all of that. The contradiction could not be clearer. Her principles are not principles. They are preferences. They are political. They are contingent on who is in the White House. Hawley's argument is devastating. He did not need to argue about the merits of any particular ruling. He did not need to defend Trump. He only needed to show that the professor's principles are not principles at all. They are preferences. They are political. They are contingent on who is in the White House. When a Democrat is president, nationwide injunctions are a travesty. When a Republican is president, they are a necessary constraint on lawlessness. That is not a legal standard. That is a double standard. And a double standard is not the rule of law. It is the rule of power. The professor's admission is the most telling part of the exchange. She said she is self-aware enough to know that her view of the underlying legal question colors her perception of the remedy. That is an honest admission. But it is also a concession. She is admitting that she does not have a neutral legal standard. She is admitting that her view of the remedy depends on her view of the underlying legal question. And her view of the underlying legal question depends on who is president. That is not principled. That is political. That is the kind of reasoning that erodes public trust in the legal system. People see that the rules change depending on who is in power. They see that judges and scholars apply different standards to different presidents. They see that the law is not neutral, it is a weapon. And once the law becomes a weapon, the rule of law is dead. Hawley's closing question is the most important. He asked how the system of law can survive on those principles. The answer is that it cannot. A legal system that applies one set of rules to one president and another set to another president is not a legal system. It is a tool of political power. It is a weapon. It is a threat to the rule of law. Hawley made that argument. He made it with the professor's own words. He made it with her own admissions. He made it with logic. He did not need to shout. He did not need to grandstand. He just needed to ask the questions and let the contradictions speak for themselves. The larger issue here is not just about nationwide injunctions. It is about the integrity of the legal system. It is about whether the law is applied equally to everyone. It is about whether judges are neutral arbiters or political actors. Hawley argued that they should be neutral. He argued that principles should not switch based on who is in the White House. He argued that the rule of law requires consistency. He was right. The rule of law is the foundation of American democracy. Without it, there is no democracy. There is only power. There is only the will of the strong. There is only chaos. Hawley understood that. The professor did not. She was so focused on stopping Trump that she lost sight of the principles that make the system worth defending. The hearing ended without the professor offering a clear legal standard. She sat there. She listened. She deflected. She admitted her view is colored by her perception of the underlying legal question. She did not offer a principle. She did not offer a rule. She offered politics. Hawley had done his job. He had held her accountable. He had exposed the double standard, and he had made it clear that the American people deserve better. The question now is whether anyone in the legal establishment is listening. The double standard remains. The rule of law is at risk. And Josh Hawley is watching. He is not the only one. The American people are watching too. They see the double standard. They see the hypocrisy. They see that the law is not applied equally. And they are losing faith in the system. That is the real tragedy. Not the rulings, not the remedies, not the politics, the loss of faith in the rule of law.